Good afternoon. Please be seated. Welcome to Division 5 of the Court of Appeals. Sorry, bailiff. My name is Gilbert Roman, and I'll be the presiding judge today. To my right is Judge David Richmond. To my left is Judge Mike Berger. We have 3 cases on the docket today. There are 2 scheduled for 1:30, the 1:30 docket. The 1:30 is People versus Tibbles, and it looks like counsel are here, present and ready to go. And then the 2 o'clock is Clean Energy versus Borrego Solar. Do we have counsel here and ready to go? Very good. And then the 2:30, they're not required to have checked in yet, but I'll check anyway. Marriage of Lanham. Do we have counsel here for that case and ready to go? Nope. Okay. Let me go over some of the quick rules. First of all, let me check with counsel. Did you see the court's protocols and procedures, and do you have any questions before we get started?
No, Your Honor.
Okay, great. And for the 2 o'clock, I would ask the same since you're here.
Yes, we saw those and no questions. I concur, Your Honor.
Okay, very good. So everybody in the first 2 cases is ready to go. For those in the gallery, I would ask you if you have anything that'll make sound or a device, please turn those off at this time, as those are very distracting. And this is being live streamed and then will also be archived. So to the extent that you need to be concerned or careful about mentioning any parties in the case that deserve and are entitled to confidentiality, please keep that in mind, all right? And with that, we are ready to proceed.
Good afternoon, Your Honors. May it please the Court. My name is Meredith Rose, attorney registration number 45304, and I represent Mr. Tibbles. I would be happy to answer any questions that the Court may have about Issue 1, but I intend today to focus my arguments on Issue 2, that double jeopardy requires the merger of Mr. Tibbles' convictions for possession and introducing contraband.
You're going to start with Argument 2? I have questions about Argument 1, so I should ask them now?
That would be wonderful.
All right. Argument 1 is either has 2 parts or 1 part, I'm not sure. You raise the issue of the tendered mere presence instruction, and the court declined to give it. Is your argument that the mere presence instruction was necessary to be given here, or is your argument that the mere presence instruction was tendered as a theory of the case instruction, and we should analyze it as a rejected theory of the case instruction, which is a somewhat different body of law?
That's true. My argument is that the
Or
mere
both, I guess I should say.
Excuse me?
Maybe it's both, I don't know. Go ahead, I'm sorry.
I do think it's an accurate statement of the law, but my argument is that this instruction embodied the defendant's theory of the case and should have been given, if not word for word, then at least modified into a theory of the case instruction, and that it should be analyzed under Nunez and cases of that ilk.
So under those cases, under theory of the case instruction, there is a body of law that says what you suggest, but my question is, where in the transcript did the counsel for defendant advise the court, or the prosecutor for that matter, that what was being tendered was a theory of the case instruction?
Although defense counsel didn't use that phrase, theory of the case instruction, it was offered in the context of the jury instruction conference, and it very much embodied his theory of defense. In the closing arguments, defense counsel argued that the spoon that was found in my client's cell was not his, that there was no fingerprint analysis on that spoon, that merely because he was in the cell with this object didn't rise to the level of possession or introducing contraband.
But if the court has a duty, as the cases say, to work with the defendant to craft a theory of the case instruction, if the one tendered is not acceptable, isn't there some burden on counsel to let the court know, I'm tendering this as a theory of the case instruction, if you don't like it, let's try to craft one that works? I just didn't see anything like that in the transcript here. Nothing that called to the judge's attention, his duty to do that.
I think defense counsel could have been clearer with the tender, but in the discussion of that instruction, the district attorney actually refers to it and says that this mere presence instruction is highlighting the theory of defense. And I think that defense counsel's argument surrounding this instruction should have put the court on notice that it really embodied more than just an instruction on the law, but an actual theory of Mr. Tibble's case.
Okay, but you do concede that defense counsel never used that phrase.
He didn't use that phrase,
And he
Your
never
Honor.
asked the judge, in effect, help me craft the instruction that'll work.
No, he didn't. But
Well, he didn't do two things. First, he didn't say, Your Honor, here's my theory of the case instruction. He didn't do that. And then when the judge said, no, I'm not giving that, the lawyer didn't say, and by the way, you have a duty to work with me to craft an acceptable theory of the case instruction. He did neither.
that's true. The discussion around the mere presence instruction was a little bit complicated because the district attorney actually tendered an instruction first, which had to do with the definition of possession. And so there was some back and forth going on, and it looks like given that discussion, the trial court said, you know what, I'm not going to do either of these instructions, and that was the end of the conversation.
So on top of all of that, do you have a plain error? Is that the standard of review for that issue?
I think by submitting that instruction, counsel preserved the argument for review because there was, the trial court had the opportunity to evaluate this instruction and make a ruling whether or not to give it. So my position is that this court should review for either structural error as a complete denial of a theory of defense instruction or at a minimum as constitutional harmless error standard.
Okay. Now, you have an issue that you would like to talk to us about.
I would like to just raise 2 points about issue 2 in particular. I'd like to emphasize first that under Reina Abarca and another division's recent decision in People v. Jameson, that possession is a lesser included offense of introducing contraband, making while confined. And I also want to address the Attorney General's argument that the 2 convictions here were based on factually distinct offenses because that is simply not supported by the record.
If we don't disregard Jameson, which we could do, is Jameson dispositive?
Absolutely, Your Honor. The factual scenario in Jameson is almost exactly the same as the issue here. It's an unpreserved double jeopardy objection to the merger of possession of contraband into introducing contraband, making while confined. And the Jameson division applied the strict element subset test from Reina Abarca, compared the elements of the 2 crimes, concluded that possession of contraband is a lesser included offense of introducing, that the crimes should merge, that it was plain error in that case under the Colorado Supreme Court's decision in Patton v. People, which established that possession of a controlled substance merges into manufacturing because logic dictates that that control is required in the production of the substance. And the division in People v. Jameson also distinguished a case that the Attorney General here relies on, which is People v. Etchells, and said that Etchells didn't control the outcome in Jameson because that case was either not on point or it was not good law following Patton and the Colorado Supreme Court's decision in People v. Abiodun.
That's an argument that Jameson was wrongly decided, right?
I'm not sure I understand.
Well, I thought the people were arguing that Jameson was, I think they have to be arguing that Jameson was wrongly decided in order to win on that issue.
They didn't have a chance to address this, to address People v. Jameson because that case.
later.
Yeah, it came out after this case was fully briefed.
But you included it, though, as a supplemental, right, authority?
That's right, Your Honor. And I would urge this division to follow the analysis in People v. Jameson, which would lead this division, I believe, to conclude that Mr. Tibble's convictions would have to merge. And even the Attorney General acknowledges that if identical evidence supports the convictions for possession of contraband and introducing contraband, making while confined, that the offenses have to merge. Instead, she argues that here, the two convictions were based on factually distinct offenses, but that's not the case. And we can tell that that's not the case by looking at the charging documents and also by looking at the jury instructions here. The charging documents allege conduct involving the same object on the same day and in the same place. Count number 1, which was the introducing count, alleged that Mr. Tibbles knowingly made a shank on March 21st, 2016 in the Adams County Detention Facility. Count 2, which was the possession count, alleged that Mr. Tibbles obtained or possessed a dangerous instrument, which was a sharpened spoon, on March 21st in the Adams County Detention Facility. So there was no attempt made in the charging documents to distinguish between the alleged acts of introducing a contraband object and possessing a contraband object. And the same is true for the jury instructions. On these two offenses, the jury was given the standard Colgi elemental instructions defining the offenses, and nothing was specified in those instructions or on the verdict form that would separate the acts of introducing and possession of contraband. The Attorney General relies on the Walhoff case for the proposition that double jeopardy doesn't prevent separate punishment for successive or factually distinct offenses. But Walhoff and its companion cases like Quintana are not directly on point here, because Walhoff and Quintana were addressing the issue of a unit of prosecution for sexual assault. And so the defendant in those cases was convicted for the same offense. And the issue before the court was, what is this unit of prosecution, and did the evidence in those cases show that there were actually different courses of conduct to support multiple convictions for the same offenses?
You probably haven't seen it, but the Supreme Court announced this morning a brand-new double jeopardy case. Have you?
I have not seen that, Your Honor.
I was going to ask both counsel whether that has any bearing on the disposition of this case, but obviously if you haven't seen it yet, and that's understandable, you can't answer that.
I'm sorry, I can't. I'll have to take a look at it and then see if it's something that I should file as supplemental authority for this case. The Colorado Supreme Court has made it clear in cases like Lesky that the strict element test, when you're looking at whether an offense is a lesser included offense of another, that an appellate court doesn't reevaluate the evidence. They don't analyze the actual evidence that came in at trial. And instead, in terms of double jeopardy and merger, appellate courts look at the way that the offenses were charged and also whether the elements are a subset of the other. And Rock, which is a Colorado Supreme Court case, also stands for the proposition that a lesser included offense merges as long as it's based on the same criminal conduct. But even if this court does look at the Walhoff factors, the Attorney General's argument still fails because there was no evidence presented in this case for separate courses of conduct. There was nothing that separated the possession from the introducing in terms of place or in terms of time. There was no evidence of an intervening event or a change in volition for Mr. Tibbles. And because the charging documents, the instructions, and the evidence all demonstrate one course of conduct, Mr. Tibbles' convictions must merge. I'd like to save my remaining time for rebuttal if this court has no more questions at this point.
Just so I'm clear, if we were to agree with you on this point about merger, what would we have to do, remand it to correct the minimus? His sentences that were concurrent, and they've already been served, as I understand it.
They have not been served yet at this point. Mr. Tibbles is still on probation for this offense, and the remedy here would be to remand for vacating the possession charge.
Thank you, Ms. Rose. You have 3 minutes, 4 seconds. Ms. Carty.
Good afternoon, Your Honors. Counsel for the appellant. My name is Jennifer Carty, registration 48991, and I represent the people in this matter. And if it's all right with the court, I'd like to start with issue 2 as well, as I anticipate that will generate the most discussion. The defendant's convictions for introduction of contraband in the first degree, making while confined, and possession of contraband in the first degree do not offend the principles of double jeopardy and do not merge because they are based on separate conduct. As the court clarified for us in People v. Rock, merger of convictions is not a function of statutory elements alone. Even when elements are a lesser included of another offense, they can still stand as separate offenses if they were committed by distinctly different conduct. So how do we figure out if we're dealing with separate conduct? Well, our court has also told us that there's no specific list of factors that is dispositive for each case. We must look to the crime itself. And the ultimate inquiry is whether the evidence was sufficient to support distinct separate offenses. And here it was. Yes, there are common factors that we look to. Did the prosecution present these offenses as legally separable? And that comes to us from Quintano. Was there anything that indicates a volitional departure? Was there anything that indicates a temporal departure? Here, the prosecution absolutely treated these offenses as legally separable. The charging documents used different words to describe the object. They used one word to describe when the defendant was making the object, and they used another word to describe the object once it was completed. I do not believe this was an accident. Yes,
But
Your Honor.
counsel, let me ask you this. You use the words making and possessing, is that right? Possession?
Yes, Your Honor.
Doesn't making while confined necessarily establish possession?
Yes, when that's all the evidence we're dealing with. However, what we had before the jury and the way this was argued by the prosecution was that there was a making period and then there was a continued possession period. And my colleague relies on Patent v. People, as did the Jamison Court. However, Patent v. People specifically says it would have had a different case in front of it had the period of possession exceeded the period of manufacture. And that is the different case that we have before this court. The period of possession exceeded the period of manufacture when the defendant took the sharpened object and walked over to his bed and tested that sharpened object and cut a hole in his mattress and cut a hole in a brand new blanket. He further possessed that sharpened object when he sat the object down on his desk. The instruction that was given to the jury included a volitional and temporal concept within it. It required the defendant to be aware that he had a completed dangerous object for a period of time sufficient that he could have terminated it. And he didn't do that here. He sat it on the desk. He didn't throw it under the bed. He didn't toss it out of the cell. He didn't, get rid of the sharpened edge and make it blunt again. He chose to continue his possession after completion.
So is your argument that the Jamison case was wrongly decided or
The Jamison,
something different?
yes, but for different reasons. The Jamison court didn't analyze whether there was separate conduct argued or whether there was evidence to support separate conduct. And here the prosecution did that. The prosecution specifically used different words in the charging document and argued it differently to the jury, using words like, then he possessed it, and attaching specific pieces of evidence to each offense for the jury to consider, and directing the jury to the possession definition within the instructions.
Let me make sure I understand your argument. So you're saying, once he sharpened the spoon, I think it was?
Yes, Your Honor.
Once he sharpened the plastic spoon and basically turned it into a weapon, the manufacture was complete at that point.
Yes, Your Honor.
And then he basically used that tool that he created, that he manufactured, and he ripped apart the bed or sheets or something?
Yes, Your Honor. He tore a hole in the mattress and his blanket.
And that was the separate offense of possession.
I believe that's when the period of possession started based on the evidence, yes.
And I didn't understand your answer to Judge Rahman. You say that Jamison is wrongly decided, or you say this is distinct from Jamison?
I think if the court believes that my argument concerning separate conduct is correct, then Jamison is a different case. But I also believe that the plain error analysis that was conducted in Jamison was incorrect.
And why?
The Jamison court expected the trial court to disregard the only case that dealt with these specific offenses and specifically said that they were not lesser included. And to be fair, the analysis was brief. There was some confusion about which section of the statute that it dealt with. However, it was the one case that dealt with these two specific offenses and said they were not lesser included, and expected the trial court to then instead look to a line of cases that deals with an entirely different offense, and it's a single statute versus two statutes like we have here. And we have other cases that distinguish these two offenses based on policy underpinnings. We have cases that were about contraband that specifically rejected relying on possession cases, stating that possession within a penal institution is a different offense with different repercussions and different policy, and that indicated we're stricter on offenses that occur within a penal institution. And the Abiodun case, which the Jamison Court relied on, talks about how when we have two offenses with two different names and two different statutes, that's indicative of the General Assembly's intent to punish them as separate offenses.
Did you read the Supreme Court's case this morning?
I did not, Your Honor. Likewise, based on all of those things, and then having on top of it that the Reina Barca test came out afterwards, and so the lesser included analysis itself was in flux. And we have a record in this case that demonstrates the confusion that existed at the trial court level. The trial court thought that they couldn't merge because they were the same level of offense. The prosecution suggested that arguably they were lesser included. The defense counsel said, no, they're not lesser included. It's indicative of the fact that the court was not sure what it was supposed to be doing, and plain error, the trial court has to be able to avoid the error without the benefit of an objection, and I don't think that was present in this case or in Jamison. As far as the mere presence instruction is concerned, I believe that the proper standard of error is harmless error. All of our cases that deal with a theory of defense instruction apply harmless error. Even when we're dealing with a missing element in an offense or an improperly worded instruction on the elements of the offense, we still apply harmless error. Structural error is reserved for the most serious of errors within the trial and ones that make harmless error analysis impossible, and I don't think that's the case here. I think it's entirely possible to analyze the error, particularly based on the fact that defense counsel was able to argue the theory of defense in his closing and did so.
Do you think the defendant preserved any error resulting from the failure to give a theory of defense instruction?
I think, as my counsel said, that it's somewhat unclear. I think the prosecution treated it as if it had been offered as a theory of defense. Those words were never stated. But even assuming that this was a theory of defense instruction, I think the Simeon holding still works for us because Nunez addressed a theory of defense instruction and still said that if the other instructions encompass the theory of defense, it does not need to be provided. And the Simeon holding said that mere presence is encompassed within those 5 stock instructions. So regardless of how you treat it, I think it was not error not to give it. And as I said before, even if this court concludes that it was error not to give the mere presence instruction, it was harmless. Defense counsel was able to make his arguments about that theory in closing, and the evidence was overwhelming. The defendant was issued a brand new spoon and a brand new blanket. He was locked inside a single occupancy cell by himself. There was testimony that the door of the cell was not left open and that he did not receive visitors. And the very next day, there's a plastic spoon with a shaved point and shavings in a grate and holes in a mattress in his cell. The court wasn't required to give the mere presence instruction, and even if it was error, the defendant was able to give his theory of defense in closing, and the evidence supported the verdict. If there's no further questions, the people respectfully request that the court can affirm the defendant's convictions.
Let me ask you about, if it really was a theory of the case instruction or a theory of defense instruction, doesn't the law say that the ability of defense counsel to argue to the jury is not an adequate substitute for a proper theory of the case instruction?
It's not an adequate substitute, but it is a consideration that is permissible when addressing harmless error. And I would say that that is one of the reasons why it is not, or why it is a harmless error, that he was able to argue it sufficiently. But in addition to that, I think the law supports that if the 5 stock instructions were given, it encompasses mere presence. So even without that, and we also have the possession instruction here, which indicates that, which the trial court noted encompassed the concept of mere presence because it required a conscious awareness of the possession of the dangerous instrument for a sufficient time that the defendant could have terminated it. So just being around wasn't enough. It required evidence that he was aware of what he was doing and aware that he possessed the object. Thank you, Your Honors.
Thank you, counsel.
I have just 2 quick points to make in rebuttal. The first is that the Attorney General today is arguing that Mr. Tibbles possessed the sharpened spoon and used it to cut the blankets and the mattress in his cell, but there's no evidence at trial that he used that spoon to make any holes or cut the mattress. There was testimony that when they entered the cell that there were holes in his blanket and there was holes in the mattress, but there's no evidence that he may have used that spoon or any object in particular to do that.
Isn't that a reasonable inference?
It might be an inference, but it's not, the evidence, there was no evidence about it. And so there has to be, some evidence that supports 2 different courses of conduct here. And just having holes in a blanket and a mattress doesn't rise to that level.
Well, is it enough that he didn't, as she put it, throw it out the cell door?
No, Your
Does that
Honor.
indicate possession possession for a period, voluntary possession for a period of time that followed manufacture or introduction?
It's still not 2 different courses of conduct. And for all that the evidence showed at trial, and I've read the transcripts a number of times trying to find any evidence that there were 2 different courses of conduct, but the evidence showed that for all the officers knew, he may have finished sharpening that spoon at the moment they opened their door. There was no testimony that he ever held it or touched it or used it. There was just, and he wasn't found on it.
Do we know what day he was issued the spoon?
He was issued the spoon the day before they found it,
So a 24-hour period elapsed.
more or less.
But you don't know when he manufactured, and you don't know when he finished manufacturing, assuming he did.
Exactly.
Okay.
And the DA also argued in the closing argument at trial that he made it and then he possessed it, but it's axiomatic that closing arguments are not evidence, and there was no development of that theory through the testimony of the 2 officers, and the 2 officers were the only folks who offered any evidence at trial. They testified that they opened the door and there it was.
If the jail officer had testified that the only instrument capable of cutting the mattress and the sheet was this spoon, would that have been enough?
I still don't think that there was a separate course of conduct. A person who creates a dangerous instrument does so with the intent to carry that thing around, I think we can assume, and to use it either for protection or in some kind of offensive manner.
Not necessarily. They might have made it for a friend, for another inmate.
I believe there's one course of conduct to introduce an object and then to continue to possess it. And there has to be something that interrupts that act of possession. And may I continue?
Please, go ahead.
And here, there's no intervening event. There was nothing to interrupt that one course of conduct.
He didn't say, "I'm done now manufacturing it, now I'm going to possess it."
That's right. Maybe if he'd given it to somebody else and taken it back, if he'd, maybe loaned it to somebody, or I guess that might be able to support 2 different courses of conduct, but here, there just wasn't evidence to support that.
Thank you, counsel.
Thank you, Your Honors.
And I gave the other side 30 extra seconds. Would you like a 30-second? Zero reply.
I would just ask the court to focus on the fact that time is not a dispositive factor in all cases. It's very crime-specific, and I believe that there were 2 courses of conduct and that we have evidence that supports there was a volitional shift, and that the jury instructions directed the jury to a temporal shift where the jury had to consider a continued possession, and that we have Patton v. People, which does talk about how that's a different case. When we have possession that exceeds manufacture, that you can look to see if there are 2 different courses of conduct. Thank you, Your Honor.
Thank you, counsel. Thank you both for your fine arguments. The case will stand submitted, and an opinion will issue in due course. We will set up now for the second case of the day, Clear Energy Collective versus Borrego Solar. And counsel, you were both here earlier when I went over the protocol, the rules, and nobody at either table had any questions or concerns. So whenever you're ready, counsel, we can begin.
Good afternoon. May it please the court, Roy Penny on behalf of the plaintiff appellant. And what I would like to do, the court issued its order talking about foundation for knowledge. So I do want to talk about that. And in particular, I want to talk about 2 aspects of that. And of course, this is a specific jurisdiction case. So what are the minimum contacts that arose here, particularly those that I don't believe are significantly disputed, that would support jurisdiction? And as the court, I'm sure, is aware, in the Foundation for Knowledge and also the Burger King case, Supreme Court case, talked about 2 different things that you can show to establish specific jurisdiction. And the Burger King case identified deliberately engaged in significant activities. And the court also talked about, and there was an or in between these, created continuing obligations. And in the Foundation for Knowledge case, mostly the court didn't specifically talk about created continuing obligations, namely the second element of this, but it found that overwhelmingly there were enough significant contacts, significant activities to support jurisdiction.
So, Mr. Penny, is it
Yes.
your understanding that all 3 elements of the specific jurisdiction test are in play today?
I guess so. I didn't see any significant argument from the appellee that there would be some sort of inconvenience to them in coming to Colorado. So I think I don't think exercising jurisdiction is unreasonable in any respect. It seems to me it's minimum contacts that they're in the appellee's brief. They seem to indicate that there needs to be some sort of continuing obligation to distinguish. In Burger King, there's the recital or the statement that a single contract can't support jurisdiction unless there are these significant activities. So that's what I believe the crux of the
So what are
argument
these
is today.
significant additional contacts then beyond the contract?
There's the significant activities can arise in connection with one contract. So the significant activities here that I want to call the court's attention to, you look at the length and the breadth of the relationship. And in prior negotiations over this contract can be considered. The sheer magnitude of the contacts in terms of performing the contract. And then finally, continuing obligations arising out of the contract. And in specific here, what we're talking about is paragraph 18 of the contract and paragraph 37 of the contract. So you have actually more facts here than you do in foundation for knowledge. And so looking at, this was a very long process by which these folks came together in September of 2015 to enter into their contract. And I would draw the court's attention to court file page 383, which are some emails from a year previous. And it talks about, these are Borrego's goals with respect to CEC. They said, what we want is, Borrego's goals are to feed the EPC machine that drives our bottom line.
Well, can I go back to my earlier question?
Sure.
My understanding is you prevailed on the first prong of the test, both before the Supreme Court original proceeding and afterwards. Am I right?
No, we
No?
lost across the board on everything.
I thought the judge said that Borrego had purposely availed itself of doing business, both
Well,
before and after.
Maybe I stand corrected there. What happened in the trial court, the Supreme Court didn't reach the issue, never got to specific jurisdiction. The trial court did seem to indicate in a paragraph of her opinion that there were significant contacts sufficient to support jurisdiction, but the analysis was muddled in the sense that the court used continuous activity in that same order, in the same paragraph, which, in my opinion, was borrowed from the McGill opinion and intermixed into there.
So was the error the court made, as you see it, focusing on prong two, which is that the litigation has to arise out of the purposeful availment of the defendant in Colorado, is that where the court went astray in applying this continuousness requirement?
Yes. I don't, but in terms of what's facing this court, I don't see the appellee trying to defend that. I think they're back on minimum contacts again, and I think probably, since it's de novo, this court has to take a look at that as well. I wish that were true. I wish that the court had very clearly, the trial court very clearly indicated, yes, there are very sufficient minimum contacts here. If that's the case, then it did very clearly, in my view, make an error with regard to the arising out of. It seemed to indicate that the overall presence of Borrego in Colorado was relevant to whether it arose out of. In other words, there was some evidence in the case about Borrego having an employee in Boulder. Borrego wanted to do some other business with CEC. So I think I'm speculating that's where I think the court got off track.
If we agree with your argument as to Borrego, what do we do about 1115 Solar?
Yes, Your Honor, and that has to do with the Griffith case and the Meeks case. And as you are aware, with regard to documents submitted to the trial court that can form the basis under Archangel and all the other cases of specific jurisdiction, the trial court can look at these documents and reach a decision as to whether there's a prima facie showing based on all these minimum contacts to support jurisdiction. But in Griffith and Meeks, the Supreme Court indicated that that was not the case with regard to alter ego. So in Griffith and Meeks, both had to do with nursing home cases where there was an operator of the nursing home in Colorado, and then there were 9 entities upstream, various parent entities, and the trial courts in both cases had said, all of those get merged, we have jurisdiction over all of you, and the Supreme Court said no. We have to, in Meeks, the court ended on its last page, which said a more nuanced approach is appropriate in connection with alter ego. So if you have conflicting allegations, the trial court can't rely on the documents. There has to be a hearing. So that's the way we went in the trial court. We said we need more evidence here to see whether the jurisdictional contacts of Borrego could be imputed to 1115 Solar. And as it turned out over the course of the case, 1115 Solar has no presence whatsoever, no office space, no employees, no bank account, no nothing. It's just purely, and it doesn't show up anywhere in the documents. In the emails, all of the communications occurred with Borrego. So I think the court should affirm what the trial court did was correct in that respect, which is to say, if it's going to be disputed whether this alter ego situation can arise, we need more facts for the trial court to be able to entertain a more nuanced approach to this. So in hindsight, if we had known everything that we know now about 1115 Solar, probably we could have put enough facts in there initially to overcome that. But at this juncture, in order to comply with Griffith and Meeks, I think there does need, if they're going to contest it, then there does need to be some kind of a hearing on that, or at least an opportunity to provide more facts to the trial court to allow that to occur. So to me, it's just put it back to the trial court and allow the trial court to do what it was intending to do, at least during part of the case. But it's not an out for 1115 Solar. They just don't walk. And I would call the court's attention to something else. Well, it's not a get out of jail free card for them, the way this has gone down. The court in Foundation indicated that, particularly since this is a contract case, it's a 229-page contract for development of $20 million worth of solar facilities. It's not very easy to go through this, but the court did indicate that that's where the initial inquiry should go. It should provide guidance to the element of purposeful availment and minimum context to look through what the contract said these folks needed to do. And in particular, I want to make sure that something didn't get overlooked in the 229 pages, and that's all of the different contracts that were required to be reviewed in Louisville in connection with making this deal happen. And the reason I mention that is because these are all substantial activities. The folks out in Oakland were sending all these documents to Colorado, and there were massive numbers of contracts. For instance, what they term project agreements in Exhibit B, and that's Court File 891. There were 29 separate contracts that needed to be evaluated in Louisville.
Am I right that there was litigation instituted either by 1115 Solar or Borrego in California
Yes.
that was dismissed? Was it dismissed based upon the pendency of the litigation in Colorado?
No, the litigation in Colorado had nothing to do with it. What happened there was people got educated, including myself, as to whether if you have a registered agent in a state, does that confer general jurisdiction? So it's a McGill analysis, and the Supreme Court has a case on that as well. So CEC, the appellant, had a registered agent because they transact some business in California. So 1115 Solar just served the registered agent and assumed they were good to go on that. So they didn't have all of the allegations in there that go into the minimum contact analysis. So when their case came up, the court there said you haven't carried your burden of showing these minimum contacts, and that's what happened there. So there was no adjudication on the merits in terms of anything that would be, applicable here.
Did that case get appealed?
It got appealed, and the Court of Appeals of California affirmed the dismissal, so that case is gone, dismissed, and I think there was an attempted appeal to the California Supreme Court, but that was not entertained.
So, counsel, you have 2 minutes left.
Very well, Your Honor. I
Let me,
was
let me
intent-
ask you to
Sure.
clarify, with respect to 1115, excuse me, with respect to Borrego, you're urging us to overturn the court's ruling that there's a lack of specific jurisdiction.
Yes.
With respect to 1115, I think what I heard you say was we should remand it to the court to have further hearings or findings with respect to the alter ego relationship between the two entities.
Yes.
So
and
it's
that-
two different results, in other words, two different aspects of our order that you're seeking.
Yes, Your Honor. That's absolutely correct.
Okay.
Of course, the alter ego is just so much more fact-intensive, and it can't come in on the documents. Okay, so I do in terms of the breadth of the amount of work that this matter required, of CEC, if you look at those, Exhibit B, Exhibit D is another 7 additional environmental reports, surveys, all this stuff that had to be reviewed out in Louisville. Exhibit J, there are tons of title issues that are important. So basically, bottom line, the way I look at this is, it has to do with foreseeability. If, broad brush, can Borrego out in California really complain that this has occurred the way it has occurred? Because the contract required that all of these things be done. And they knew that CEC was based in Colorado, and they communicated with CEC in Colorado via phone, via email, provided all these documents, so, and all these submittals that were required. So they're really, they can't be heard to complain that they didn't know that if something went awry, that they would be hailed into court in Colorado. Thank you, Your Honor.
Thank you, counsel. Your time has expired. And Mr. Fawcett, before you start, so my understanding is that you were approved as pro hoc vice in the district court, and that your opposing counsel does not object to you arguing today?
No, it would be totally unfair, Your Honor.
Okay.
We have no objection.
Yes, thank you, Your Honor. I appreciate the court's indulgence. We had not realized that a separate motion should have been filed in the Court of Appeal after the admission pro hoc in the trial court. May it please the court, my name is Jeff Fawcett. I'm here today representing appellees Borrego Solar Systems, Inc. and 1115 Solar Development, LLC. I do want to focus most of my time on answering the court's questions that were submitted before the argument, but I think it would be useful to clarify a few of the points that were raised previously. As to what happened below in the trial court, the argument that was made by CEC was that jurisdiction could be had over Borrego, not because just of the APA, the Asset Purchase Agreement, but due to collateral contracts that were pleaded in the First Amendment complaint and other contacts between Borrego and Colorado. The only contact between 1115 Solar and anything in Colorado is the fact that 1115 is a party to the APA. So it's been conceded there's no other contact with 1115. So plaintiffs focused on these alleged other contacts Borrego had. There had been an effort by Borrego to bid on another contract involving CEC. That didn't result in anything, but there'd been a bid. Borrego at one point hired an employee in Colorado. So these other contacts were brought into play. The trial court found that the APA was not sufficient to result in specific jurisdiction over Borrego, but then it looked at these broader contacts and said, well, there's general jurisdiction because you're here for these other purposes.
But did the trial court rejected specific jurisdiction on prong 2 of the specific jurisdiction test? Is that right?
I believe that's the way the trial court looked at it, Your Honor. Yes, because I believe what the trial court, in the trial court's mind, the broader array of contacts did not result in the lawsuit, in what was at issue in the case. So there was no arising out of element.
But you lost on prong 1, both before the Supreme Court proceeding and after.
I don't believe the court ruled specifically that we had purposely availed ourselves of being the jurisdiction through the APA. I think what the trial court was saying was, by virtue of all of these, the panoply of things that CEC alleged, there had been some reason to think Borrego was sufficiently here in Colorado to be subject to jurisdiction, and that's why the trial court turned to the general jurisdiction issue, which the Supreme Court said was absolutely wrong. There's no basis for general jurisdiction following the more recent cases involving car
Let's
companies.
cut to the chase. I mean, tell us why we are not required to reverse this judgment based upon foundation.
Absolutely, Your Honor. I think foundation is, the first question was, does it impact the disposition of this case? It is illustrative of where the court found jurisdiction, but there's a continuum there. As the court recognized in Foundation for Knowledge, as the Burger King court has recognized, as every court that's looked at a jurisdictional issue has said, these are fact-specific analyses. And there's a continuum. Burger King, Foundation for Knowledge both say a single contract is not sufficient for jurisdiction over a non-resident defendant. Then the Foundation for Knowledge court goes through all of the other facts that were in the record there. So when we compare and contrast those facts to what we have here in our contract, and just to highlight a few of the things that the Foundation for Knowledge court found, the complaints involved wrongs against the Colorado public charity, which had an effect in Colorado. The plaintiff had previously worked with the defendant on 2 prior projects here. The defendant traveled to Colorado on numerous occasions. The defendant would collect revenue under the ongoing agreement. There would be revenue collected by the defendant, and then they would remit 70% of that to the plaintiff on an ongoing basis. A monthly hosting fee was going to be charged by the defendant to the plaintiff. The defendant would host the modules for the plaintiff. There was a significant back and forth in the contract involving with developing the software. So there's this feedback loop going back and forth between the 2 parties. Numerous other additional contacts. But more fundamentally, in that case, and in every case they've cited where jurisdiction was found, the fundamental object of the contract was something occurring in the jurisdiction where the non-resident defendant was being tried to be brought into court. In our case, the fundamental object of this contract is to build solar power plants in Massachusetts. Borrego develops and builds solar power plants. CEC is a financing partner. They use Morgan Stanley in New York to do that. Borrego was looking for some help financing these construction projects in Massachusetts.
So as you see it, where should this litigation be heard?
Well, Your Honor, we thought it should be heard in California, and we filed the lawsuit in California. There was some miscommunication about what happened in California. We sued them basically the mirror image of this case, sued them for breach of the APA. They at first sought to change venue, but then CEC filed a motion to quash for lack of personal jurisdiction. The trial court granted that motion, said there was no personal jurisdiction. Same kind of arguments being made about what the APA means and whether there's jurisdiction. Our trial judge there said, you want to sue them? Sue them in Colorado. They want to sue you? They can come sue you here in California. The Court of Appeal in California affirmed that for the lack of personal jurisdiction, and that's where that case is.
So I have a similar case or question. I'm trying to figure out where the merits of this case ever gets heard, because I know that you even filed in federal court, and they said because you didn't have complete diversity that they wouldn't take it, and they sent it back.
What we sought to
California
remove this
didn't take
case,
it.
but yes, Your
Go
Honor. I think where we go next is Massachusetts, to be frank, because there's jurisdiction there. That's where the power plants are. They have a presence there. They've been in litigation both as a plaintiff and a defendant in Massachusetts, as has Borrego. So that's where we go next.
But neither of the parties is located in Massachusetts, as I understand.
They're not headquartered, but they both have operations there. And that's the thrust of this contract. If we look at the actual contract, counsel referred to how long it is and how dense it is. Well, if you go through it, the contract was for the purchase and sale of assets related only to solar power projects in Massachusetts. Paragraph 7, Section 7 of the contract discusses if we're going to have a proration issue on some of these leases, because all of these projects involve leases, that proration is going to be governed by the custom of Massachusetts. The third-party risk section, Section 13 of the contract, all of the risks identified as third-party risks relate to Massachusetts and its solar renewable energy credit system. Those are the third-party risks.
So which of your arguments is stronger? Your first argument, as I gather, is that your client didn't purposely avail itself or themselves of the privilege of doing business in Colorado. And your second argument is even if they did, this litigation doesn't arise out of that purposeful availment. Which is stronger than the other?
Your Honor, I think you never get to the arising out of because there's no purposeful availment. There's nothing in this asset purchase agreement that would give either Borrego or 1115 Solar the knowledge that they were availing themselves of the privilege of doing business in Colorado. They were doing business in Massachusetts and California. The counterparties for all these agreements that council discusses, as far as there's all these things going back and forth, we were looking at these things in Colorado, all of the counterparties in those agreements are in Massachusetts. The only two projects that arose out of this contract, the Wareham and the Carver project, the contracts to build those projects were between Borrego and Morgan Stanley entity that is domiciled in New York and a corporation under the laws of Delaware.
But your client knew, obviously, that they were entering into a contract, a multi-million-dollar contract with a Colorado entity. Your client, at least according to the allegations of the complaint, which we basically have to treat as true, made repeated communications. I think the allegation was 4 per day
Well,
from California into Colorado. How can you say that your client wouldn't reasonably expect that if things went awry, that they might be required to account in a Colorado court?
So two answers to that question, Your Honor. First of all, the reference to the 4 contacts per day, that's part of the evidence they tried to submit in the motion for reconsideration. The trial court said, I cannot consider this motion for reconsideration evidence because you provided me with no information as to why it was not presented earlier. So the evidence that he keeps citing about these 4 contacts per day, this court should not even consider that evidence. And that's the Worden affidavit that was submitted only in connection with the motion for reconsideration. And the trial court rejected that and did not hear it, and that has not been appealed. They did not make that an issue for appeal.
But I don't understand that. Didn't you refile your motion to dismiss under 12b-2?
We did not, Your Honor.
Didn't you renew it?
We filed a renewed motion to dismiss.
Well, what does that mean you filed did you file a paper saying, here's my renewed motion to dismiss?
Yes, Your Honor.
And wasn't the plaintiff entitled to respond to that motion without regard to any motion for reconsideration?
I don't believe so, Your Honor, because we provided no new argument or anything. All we said was the order from the court had said jurisdiction is granted on the basis of general jurisdiction. The Supreme Court said, no, there's no general jurisdiction over Borrego. So, and what the court had also said in that order was, there's no specific jurisdiction. So we said, all you need to do now then is enter a judgment of dismissal because you've already said no specific jurisdiction. The Supreme Court says no general jurisdiction. And they had said that the only basis for jurisdiction over 1115 is by virtue of being an alter ego of Borrego. So there's nothing left to be done. And the court, they then, at the same time we filed that motion, they filed a motion for reconsideration and submitted this new evidence. The court's order denied that, said there's no basis for it, and there's no basis for me to consider this evidence. Now, they could have appealed that, I suppose, but they didn't. And then the issues presented for review, there's nothing about that evidence. But more importantly, Your Honor, going back to your other question about shouldn't they have been on notice, I don't think so. If the court actually looks at this APA, everything about the APA is Massachusetts. It's also about contracts with Morgan Stanley entities which are not in Colorado. And that's who the ultimate contracts were with.
These are extremely sophisticated parties, and, if your client wanted to ensure that it wasn't subject to jurisdiction in Colorado, it could have insisted on a forum selection clause, and it didn't. Doesn't that have, at least when we're dealing with the type of sophisticated parties here, doesn't that have some consequence to your argument that, we didn't know we were going to be held to account in a Colorado court?
Your Honor, I don't think that there's any case I've seen that you can hold us responsible for the lack of that choice of forum provision. There is a choice of law provision here, and in Burger King, the Supreme Court said choice of law provisions are relevant to jurisdictional analysis. The choice of law provision in this contract, New York law, okay?
But you're not saying that New York would be the proper forum?
New York would be a proper forum.
Oh, it would be?
Yes. But I'm just saying it's more likely that Massachusetts is.
Why would New York why would these parties have sufficient contacts with New York?
I believe that
Well, I don't want to take your time up on that, because it's,
Let me ask you a question. I believe your opponent said 29 different documents are listed in Exhibit A, and these things were sent repeatedly to Colorado to be reviewed or revised. I'm not sure exactly what. Is that an accurate statement of what the contract required?
It's not entirely, Your Honor. What the APA is, so there were 2 projects that Borrego and 1115 had developed in Massachusetts. And the way these solar projects work is the developer goes into a local jurisdiction there and has to organize a whole slew of things: permitting, leases for the ground, a connection agreement with the local power utility, various local governmental authorities have to do this. So that's what all those contracts are. So the way the APA works is, these contracts are between 1115 and the counterparties in Massachusetts. They're all Massachusetts
Okay,
parties.
what's CEC's role in those contracts?
So as part of the way the APA then it works, 1115 sells its position in those contracts to CEC. CEC then transfers those contracts to the ultimate owner of the project, which in this case is this Morgan Stanley entity that's based in New York. And that's the entity that paid for the construction of the project and that ultimately owns the power plant.
So is CEC's role just to look at the contracts and say, oh, here's what we're bound by, or do they have input into how these contracts are negotiated, drafted, and put together?
The contracts by and large are already signed.
So what they mailed here was just informational purposes for
Yes,
CEC.
Your Honor.
That's what your position would be?
Yes, and I would characterize the contrast between this case and Foundation for Knowledge. CEC's role here is entirely transitory. This is not the idea of this lengthy relationship. The contract was signed in September. It was due to close in November. It closed in November on the only 2 projects that got built. Those 2 projects are owned by an entity that is not CEC. They are in the middle between Borrego and Morgan Stanley. Morgan Stanley now owns those 2 power plants, and they operate them in Massachusetts. CEC may have some financial connection there. It's not part of the record, but this is not a long-standing relationship where the object is to do something in Colorado. There was nothing that the parties intended to do here. Everything that was going to happen in Massachusetts.
On the third prong, what I call the fairness prong, do you claim that it somehow would be unfair for your client to have to defend here?
Your Honor, I don't believe the court gets there, but if the court does get there, it's not unfair to the degree of having to go halfway around the world. We're going from California to Colorado. It wasn't a prong that we argued in our appeal because, frankly, the trial court didn't get there, and we don't see any reason the court needs to. I would just like to add that we think the trial court should be affirmed not only on the jurisdictional arguments, but also on the fees award. The court there found that the parties intended that all the fees incurred should be recoverable under the fee shifting provision in the contract. The other point I would like to make is the contract section that counsel identified, section 18, when he was referring to that as a basis for keeping Borrego here. That's a part of the contract that binds 1115 solar only. It doesn't have anything to do with Borrego. The fundamental thrust of this argument that 1115, we should go back to the trial court because we need to see about imputing Borrego's context to 1115. What that really does is recognize that solely being a party to the APA isn't enough.
Was Borrego essentially a guarantor of 1115 Solar's performance?
That's the way it appears in the contract, yes, Your Honor. There's on the signature page, they added a paragraph there that said Borrego would guarantee 1115 Solar's. I don't know if it uses the word guarantee exactly, but that was the idea.
What do you say about counsel's position they should have a hearing? If we disagree with you on jurisdiction of Borrego, counsel suggests there should be a hearing on 1115's susceptibility to jurisdiction under the alter ego theory.
Well, Your Honor,
If we disagree with
if you get to that point, then that would be appropriate to have that hearing because you can't. There's not a record here to establish alter ego. If we get to that point, then there should be an evidentiary hearing on their contacts in Massachusetts and why that's what really this case is about.
Thank you, counsel.
Thank you, Your
Time's
Honor.
up, and I will give you an additional 55 seconds to reply.
I do want to dispute that these were just these contracts that the court referred to on Exhibit B, the 29 contracts, that these were somehow just things that came through across the email and somebody kind of glanced at them. These are extremely important documents. They're the only thing that you're buying. When you're buying an array in Massachusetts, what you're buying is the entitlement to actually go ahead and build it. So all of these title issues, has the landowner in Massachusetts given you permission? Has there's 9 different people that have to look at this in terms of, the Massachusetts EPA, all of those things.
Did CEC have to revise those documents? Was that why they were sent to them?
Yeah,
They revised them and they sent them back to who with the revisions?
they were actually enlisted to, as set forth in the affidavit of Catherine Warden, CF 563, Borrego actually passed off to CEC in Louisville the primary obligation that it had under the contract to go out to Massachusetts and get this stuff. And that's what those emails were that are referred to in there. So in the APA, it talks about documents being in a form acceptable to the purchaser, very standard. Because, as counsel is correct, these had to go to New York to provide the money to get the $20 million to pay for these.
Okay,
So,
but I'm just trying to get an answer. Did CEC, Mr. Fawcett gave us the impression the documents were sent to CEC for their files. You're saying no, CEC worked on these, revised them, negotiated them
yes.
with Borrego or with somebody else?
Well, they had to go, well, with the somebody else being whoever it was that was granting access in Massachusetts, and they're listed on Exhibit B.
But not with Borrego. Borrego
They
didn't
had-
have to negotiate it with them.
Well, they were supposed to. They were supposed to get all this done and come back to CEC with a turnkey package. That's what they were buying. That's what the APA provided. And they would have to get back with Borrego if any of these things needed to be cleaned up, which they did do. So the thought.
Counsel, I'm going to cut you off right there.
Very
Thank
well,
you for your
thank you.
time.
Thank you.
Thank you, Judge.
Thank you both. Thank you all, Mr. G. Also, thank you for your fine arguments, counsel. The case will stand submitted, and an opinion will issue in due course. 5 minutes. And the court will take a brief recess right now and be back in about 5 minutes. The third case behind us can now set up while we're gone.
return from recess. Please be seated.
Good afternoon. Welcome back to Division 5 of the Colorado Court of Appeals. Council were not here the first time I went through this, my spiel, so I'll do it again. My name is Gilbert Roman. I'll be the presiding judge today. To my right is Judge David Richmond. To my left is Judge Mike Berger. We have one case on the docket that's remaining for the 2:30, and that is the Marriage of Lanham case. And I see that counsel are here. And do you have any question about the procedures or the protocols of the court?
I do not, Your Honor.
Denied. Very good. Just a reminder to the appellant that you have rebuttal time, and you can ask for me to help you should you have some time that you want to save. But in the end, it's up to you, okay? And for those out there in the gallery, if you have anything, and for you too for that matter, if you have any devices that are going to make noise, please turn them off at this time. And we are being both live streamed, and then later this will be archived. So if there are any parties or witnesses whose names should not be revealed, please remember that as well, all right? And with that, I believe we are ready to proceed. You may proceed.
Good afternoon, Your Honors. My name is Kathleen Laraway. I represent the petitioner appellant and cross appellee Ruth Harris. May it please the court, we are here today on our appeal regarding a Rule 60A motion that was filed by my office on behalf of the petitioner appellant. The parties were married, and the dissolution of marriage action, this arises from a dissolution of marriage action which was filed April 4th, 2016. In that dissolution of marriage action, there were multiple real estate matters. There was a marital home. There was a home that husband had prior to the marriage. There was a home in Alaska. There were also houseboats and some ski condos, and wife had moved into a home of her own during the pendency of the parties' marriage. During the parties' dissolution of marriage, both parties testified. Husband called a witness who was the seller of the Alaska property to him. In its permanent orders, which were issued by the court ordered that the marital home, which was located at 12345 East 116th Avenue, should be sold. And from those proceeds, wife was awarded the first $96,000, and the remainder should be divided equally. This is where arises the miscalculation of the court.
Okay, let me stop you there, counsel, okay? The permanent orders were entered, I think, in June of the year, and you filed a notice of appeal timely with respect to the permanent orders, right?
That's correct.
But you're not here today appealing anything about the permanent orders. You just said you're only appealing the Rule 60 motion.
Well, Your Honor, what we are appealing is that the court abused its discretion in denying our Rule 60 motion. We would like the court to correct the clerical error in its permanent orders.
Okay. If the permanent orders motion, you're okay with the permanent orders motion had it been, let's say, applied in the way you think it should have been applied, right?
Yes,
You're not
that's-
trying to change the allocation of property. You're not trying to change the distribution of assets or any of those things that are in the permanent order. Is that correct?
That is correct, Your Honor. We
Okay.
believe the permanent orders and the allocation of the property within the permanent orders is done correctly. We do not contest it. What we contest is the court's calculation of the equalization payment is an error, and that's what we're here about today.
Okay.
So you claim that in addition to the 96,000, there should have been added to that 175,000?
Not quite, Your Honor. The math is That's close, but not quite. Essentially, what happened is the equalization payment to wife should have been approximately, and I'm going to double check my numbers, $192,177, as well as she should have received half of the equity from the marital home, which is the 12345 East 116th, which was ordered to be sold. What happened is somehow the court came up with a number of $96,000. I cannot speak for how the court got to $96,000. My guess would be they halved 192 and got to 96, which would be an error and a miscalculation.
So with regard to what you're talking about, did you see the questions that the court sent out in advance?
We did, absolutely, Your Honor. Would you like me to address those now?
Yeah, if you don't mind.
Certainly. Let me just pull them up. The court asked specifically, did the trial court substantively modify the permanent orders when it entered the order denying petitioner's 60A motion to correct the permanent orders, and if so, in what manner? My response to this is unequivocally yes. The court actually did substantively modify the permanent orders in its order denying our Rule 60A motion. And how they did so is when you look at the court's order, what they did was they made a finding that the
Who's they?
I'm sorry, the judge, the trial court, Your Honor. I apologize. The trial court made a finding in its order that the petitioner was only receiving $96,000 because she received less of the debt and more of the retirement. However, the issue that the petitioner brings to this court's opinion or attention with that is that there can be no finding by the trial court that petitioner wife received more of the retirement accounts because, as you'll note from the record, there is utterly no way to value husband's retirement accounts because he failed to produce any documentation pursuant to CRCP 16.2. So as a result, what the trial court did is they essentially said, wife's has 401ks, and we know the value of wife's retirement to be approximately, I believe, around $44,000, the increase in value of them over the time of the marriage. Husband has 2 pensions. He provided no documentation of these pensions, so the court said she could not give a portion of wife's retirement to husband, and she essentially said, I'm going to treat them as they each take their own. I mean, not ironically, but actually both parties in their joint trial management certificate specifically asked for that division as well, despite failure to disclose by husband. So what happened is in the court's order denying our Rule 60A, they substantively went back and said, we offset our property number by the party's retirement account division and the debt division. And the problem with that is that is not supported in the permanent orders in any capacity. In fact, in the permanent orders, the court treats every asset very distinctly. They go through real property, they went through retirement, they went through debt, and she specifically found in her permanent orders the division of debt was equitable. She specifically found in the permanent orders that her division of the retirement accounts was equitable despite having no disclosure. So by coming back and saying the reason that wife is only getting a quarter of the equity out of these houses is because she is getting more of the retirement is incredibly problematic because we have no idea if she's getting more of the retirement. Husband could be getting a windfall in that retirement division. We don't know.
Let me ask you this. When you filed your 60A motion, did that vest the trial court with the authority? Now, I'm not addressing whether it might have been an abuse of discretion to do A, B, or C, but did it vest the trial court with authority to substantively modify the permanent orders she previously entered?
Yes, and that was the court's second question. I would say no, Your Honor. In reviewing the case law and in reviewing the statute, CRCP 60A, there appears nothing in the law to me that would allow her to go back and substantively modify her permanent orders. 60A is, of course, a safeguard for times when there are clerical errors, and our position is that this $96,000 is essentially a clerical error. It should have been $192,000. I think it got halved twice to $96,000, although I can't speak for that myself, but that's my guess. And what has happened is essentially a 60A motion, which essentially just should have said, please just fix this math, make this order make sense. Because the problem that we are still stuck with right now with these permanent orders is that on one hand, the body of them and almost all of them say wife should receive this $192,000, but it only gives her an opportunity to collect $96,000 of it. And so we're stuck with an order that unfortunately contradicts itself and doesn't really allow for enforcement or make a lot of sense.
Let me take you back to the permanent orders, okay? I find them difficult to understand, I'll be very frank with you.
Certainly.
As to three of the properties, two of the properties, really, it says the amount that she gets from the Alaska home, the amount she gets from the property on 123rd Avenue, language is the same. It shall be apportioned from the proceeds of the sale of the marital home. No amount is given there, but you're assuming it's 50%, right?
And I'm sorry, which are you referring to?
The Alaska home,
The Alaska home? It says the marital portion for each party to be $175,000.
and that amount shall be apportioned from the proceeds of the sale of the marital home.
Correct.
That's a sentence she uses over and over again in these orders, okay? I understand with respect to those properties. What was she doing with respect to Ski Hill Road, Snowflake Drive, and the houseboat? She used the same sentence, but are you arguing that some number should have come out of those three properties for the wife?
No, we are not, Your Honor. Ski Hill Road and Snowflake Drive were essentially timeshares. Husband owned them prior to the marriage. There was no testimony at the trial court level regarding their value. And the houseboat, similarly, there was no testimony about an increase in value.
Right.
I would agree with the permanent orders that no money would come to the petitioner appellant from Ski Hill, Snowflake, or the houseboat.
So what does that sentence mean? The equitable distribution of this property shall be apportioned to the sale of the marital home. What does it mean?
Well, Your Honor, I believe it. I guess I can't actually tell you what the judge was thinking when she wrote it, but my guess is it was standard language that she's using whenever she's dealing with the division of a property. In these particular instances, she just wasn't actually giving wife any money from them.
All right, but then with respect to the Alaska home, same sentence appears, right?
That's
There,
correct.
you say, oh, that means the wife should have gotten 175 out of the 350 value, correct?
Yes, I do believe it
So
says,
you understand what the sentence means to Alaska, but you don't understand what it means. I'm not faulting you. I can't understand it either. It's not really comprehensible with respect to these other three properties, is it?
well, and I do agree with the court. I don't know why she felt the need to put that last sentence on paragraphs 5, 6, and 7.
But all you're arguing about is the $96,000 fails to account for her share of the property in Brighton, no, the property on 123rd Avenue and the property in Alaska, right? And
Yes.
if those two were properly accounted for, her share would be more like 192 instead of 96.
That is correct.
Okay.
Let me ask you a slightly different question. Can you explain to me how there was competent evidence in the record to support a finding that the value of the Alaska property was $350,000? I mean, as I understand it, the only evidence was from a witness that the trial court said she basically didn't think he told the truth on anything. But when he did say that the property was at the time of purchase was worth $350,000, he also went on to say, but it had decreased in value since the time of purchase to the time of the permanent orders. And the task of the trial court is to determine the value as of the time of the hearing. Who cares what it was worth when it was purchased? Please explain how there was any competent evidence in the record to come up with that $350,000 number.
So with respect to the evidence, and I understand the court's concerns regarding the credibility of the witness there, but what essentially the witness testified is that he had received in payment approximately $250,000. He testified that because the buyer was a friend, which his husband was his friend, he had given him, quote, a deal, I would assume. And he
Why
believed,
don't I have friends like that?
I don't know, I don't either, unfortunately.
But that was at the time of the
Sale.
quote-unquote, well, I'm not sure when the sale happened.
Well, there.
4 or 5 different times it seems to have happened.
Yes, unfortunately, in this, there are multiple, there's a quitclaim deed in the end of 2014, and then there's a warranty deed to a husband at a later date. But essentially, he testified that he thought it was about $100,000 less. I believe what the court found, and the way the court I don't want to put words in the court's mouth, but I believe the way they got to the $350,000 was essentially saying, if the purchase price was $250 and it was valued at approximately $100,000 more, then the purchase price or the value at the time of the purchase would have been $350,000. I think that the court did find that they didn't have any evidence as to the current price, but that I don't think they found Mr. Schuckman credible when he said it had decreased in value. So I think the court left it at
But he
$350,000.
was the same person who said it was worth $350,000.
Yes.
right?
I
It was
think,
only his evidence that supported the $350,000.
I think she kind of indicates, the trial court indicates in its order that he lacks credibility as to the timing of the sale of husband, but she doesn't indicate that he lacks credibility as to the value of the home. What she was concerned about was the credibility of the witness with respect to the timing of how the sale went down.
But she must have also disregarded his testimony that it went down in value. Whenever the purchase was, he testified that between then and the time of the hearing, it went down. The judge must have disregarded that as well.
I think she did, yes.
But if we can't tell, if we're all guessing today, doesn't it make sense to remand it back to the trial judge to clarify what she intended there?
Your Honor, absolutely. If we need a clarification from the trial court as to how she arrived at that value, I think it's appropriate to do so.
And you have 1 minute, 10 seconds.
I am going to reserve the remainder of my time for rebuttal, if that is all right.
Very good.
Ready? Good afternoon. May it please the court. I'm Richard Williams, registration number 11865, law firm of Helmless and Williams, appearing on behalf of the appellee. Let me answer your two questions first. I look to the issue of whether or not the trial court's order denying the CRCP 60A motion, whether or not it substantively modified the permanent orders. I would submit it did not. That what it did was provide further clarification, but it in fact ratified and reaffirmed the trial court's order.
I don't understand that. How was the wife supposed to get her $175,000 from the Alaska property?
Well, I think the court, thank you for the question, Your Honor. I think the court is sort of jumping along with the appellant's position that everything needs to be 50-50.
No, that's what the judge said. I'm not jumping along with anything. I'm just trying to apply what the judge herself said. She said the value of the Alaska property was $350,000, and each of the spouses was entitled to $175,000. How was the wife supposed to get her $175,000?
From a portion of the proceeds from the marital residence, from her retirement accounts, from the increase in value of her separate property.
But your client didn't provide any values for his retirement.
Well, Your Honor, I think in terms of the trial court and the domestic relations practice, sometimes attorneys take the position of, we're not going to try to pay for an actuarial to do this. We're just going to ask that the court use one of the other methods of valuation, which would have been a qualified domestic relations order for his account, and that's what we asked for at permanent orders.
But that's not what happened.
No, it's not what happened. No, in fact, the court didn't come up with the value, didn't use any of the three methodologies, simply set aside each party their respective retirement accounts. So I think that the premise that, that yes, the court did indeed come up with certain values for things, but then in the final analysis, what the trial court did in denying the Rule 60 motion was saying, yes, I understand why you're saying what you're saying in terms of these numbers, and that if we just did a mathematical calculation and tried to get to a 50-50, these numbers don't add up that way. But in fact, the court, relying upon both the Balance and Decision and in re the Marriage of Burford, said it doesn't have to be a 50-50 split. Remember, this was a marriage that was just over 2 years in length at the time that the wife filed for dissolution of marriage. So there wasn't a time for the actual growth of a lot of marital assets. And so that goes really to the issue of, whether or not the court appropriately said, we've got to look at the length of the marriage and give the petitioner wife a smaller portion of the proceeds. Turning to the second question you asked, because I do, based
Counsel,
upon our position.
before you
Yes.
go there,
Yes.
let me probe about your answer. In the motion denying the Rule 60, the court has the sentence that I think you're alluding to. She wrote, petitioner's assertion, mathematical mistake, petitioner's assertion fails to account for the unequal distribution of marital debt and retirement accounts in this matter, as the court had done in its order. That's the language you're referring to.
Yes, sir.
Right. Can you point us to language in the permanent orders that says the same thing? That she's unequally distributing marital debt and retirement accounts to make up for her
Right.
an evening out of the estate. I just have trouble finding that in the permanent orders.
Thank you, Your Honor, because it's not there. You know, I acknowledge that it's not.
Then isn't that a substantive reconfiguration of her rationale from the permanent orders?
Well, I think that, and then it gets to your second question of whether or not the court has the power to substantively change
Okay,
its
let's
permanent
assume
orders.
for the moment it did substantively change it. If it has the power to do so, maybe it did so. Tell us about the answer.
That's my position, Your Honor. And you look at the reality of what a Rule 60 A motion is for. Let's say that the trial court, in its original order, said that, you know, husband was supposed to get $500,000. And in fact, it was a mathematical mistake, and he was supposed to get $50,000. That's certainly a substantive change in the outcome. It's a material change in the outcome, but it's within the court's discretion and power. So I-
Wait. If the permanent order said he's supposed to get 500, but he only got 50,
No, I'm saying that after ruling on the Rule 60.
yes.
Well, but.
And changing its order.
Yeah, but I think, to put this in perspective, the way a true 60A error would come up, at the conclusion of the permanent orders hearing, the judge says orally that wife will get 50,000, but then when it's reduced to writing, it says wife will get 500,000. That's clearly some type of typographical error that is within the contemplation of 60A. I've not seen anything where the judge said, well, you know, I think I gave her too much in the written permanent orders, so I'm going to fix it now on this 60A. I haven't seen any authority that says a court can do that.
And nor have I, Your Honor, nor have I seen any authority the other way either. I think it's a case of first impression on that issue in terms of what is the
So what
court's-
should we do? We have to figure out what to do. What should we
Right,
do?
right. Your Honor, my ultimate position is that this case needs to be remanded for a number of reasons, both as to better findings on that issue, but certainly as to our underlying appeal as well. And that frankly goes to the Alaska property for a major factor. We had a couple of good old boys who have a piece of property, or a gentleman who's got a piece of property up in Alaska. He's got my client and my client's brother, who have for years indicated they want to buy that piece of property. Well, the good old boy up in Alaska decides he's going to sell it to him on a handshake, no written contract, no documentation. And as we've set forth in our brief, the analogy, and I think the way it should be treated, is an installment land contract. That there was $100,000 that was paid prior to the date of the marriage. The documentation, the evidence, not from my client's testimony, but from demonstrative exhibits, from actual exhibits, shows that the first $100,000 was paid 3 days prior to the date of the marriage. The next installment was paid a day after the date of the marriage. The only testimony was that that money came from my client's brother. And as such, that should not have been treated as a marital asset. And so we believe that the trial court created a major error in terms of making a determination that those monies came from a joint bank account. They didn't. The parties were married in January. The evidence is that the bank account was not made joint until March. So we think that this should be treated as a non-marital asset, and that you simply look to whether or not there's been gain or loss on that asset.
So counsel, does the trial court's findings of credibility or lack of credibility affect what you're saying right now?
If it was from testimony from my client, I would certainly agree, Your Honor. But when you've got documents from the checks, and you've got the bank statements, and you've got the statements of the seller that the money came from.
So it's clearly erroneous, is what you're saying?
Right, yeah. I'm saying that ruling was clearly erroneous as to how you treat the bulk of the purchase price of that asset. And if the court accepts the analysis that this should be treated as a installment land contract, then you have to look at when was the property acquired, and we've cited some case authority that it should date back to the first installment, which was the first $100,000.
But you would agree that the wife's entitled to the increase in the value, at least from January 30th, 2014, when they were married, until the day of the permanent orders, right?
Had there, yes, sir, I certainly
She's at
would.
least entitled, all right. We don't know what the evidence is or isn't on the increase in value, do we?
Yes, well, I believe we do, Your Honor. We have the evidence that the purchase price was $250,000.
What's the market value at the time of permanent orders?
That we have the evidence that we have the tax assessments, which was the only evidence, and it was admitted into evidence without objection to show the value of the property at that date, at around $170,000, so less than the purchase price.
But the court made no findings on the value at the time of permanent order. Well,
Court
she
made-
did, but she made it based on what
The speculation.
seller said.
What the seller speculated as to a value of $350,000, saying he thought he gave his friend
Is there
a
a
deal.
law that addresses whether the assessed valuation for tax purposes is competent evidence of fair market value?
I don't specifically know, Your Honor. I believe that's appropriate. In my practice, it's certainly used from time to time by attorneys in presenting in domestic relations cases.
Let me clarify what you wanted on remand. You'd like the court to reconsider whether the Alaska property is marital property at all? No, it's marital property as of January 2014, right?
No, sir. My position is it was separate property.
Okay.
Now, whether or not a portion of the purchase price that was paid during the course of the marriage from marital funds should have marital identity and be treated as a contribution from the wife to the acquisition of that property, that should certainly be considered.
And the value of the property has to be determined as of the date of the increase in value as of the date of the permanent orders has to be.
That's correct, if there was any.
Okay.
Yes. So that's certainly our position, Your Honors, as to that Alaska property, that even if it were to be treated as marital property, you have to look at contribution. And certainly, the $100,000 that's paid prior to the date of the marriage is the husband's separate contribution. The contribution made 3 days after the date of the marriage from his separate funds certainly should be treated as his separate contribution. And so those contributions, I would submit, should have been set aside to Mr. Lanham as part of this transaction as to how it was going to be treated. So that's our position with regard to how we should treat and assess the Alaska property, and that the trial court failed, unfortunately, to follow 1410-113 in terms of looking at the premarital contribution or contributions in general as to that asset. The second issue that we've raised on appeal is the issue of these retirement accounts. And again, as I've said earlier, that it's not atypical not to go to the expense of an actuarial to come up with values of these accounts just because of the cost of these proceedings, and that to simply ask that it be addressed through a qualified domestic relations order was an appropriate request. It's consistent with the case law and should have been handled by the court in that fashion.
But didn't you waive that argument? I mean, I recall seeing in the trial, I think in the trial management order, both parties seemed to agree that the court should just award each of the parties their own retirement accounts. If you did that, doesn't that just moot this argument?
Well, Your Honor, I appreciate that. Perhaps my drafting was not as artful as it should have been. Certainly, the intent was for him to keep his account, but for it to be addressed through a qualified domestic relations order. And that's not,
Well, the
and it certainly
Quadro-
wasn't a stipulation.
See, I don't understand that. I thought the Quadro actually distributes portions of a given retirement account, you don't need a quadro to say that each spouse retains their own retirement accounts. Am I right in that?
Yes, you are, Your Honor. Yeah, so it's really, again, my lack of artful drafting in terms of that document, although certainly not a stipulation and certainly something that we did raise at the permanent orders hearing, such that I don't think that we've waived the issue on appeal. Certainly the testimony at the permanent orders hearing was the proposed handling of it at that time would indeed be through a qualified domestic relations order. So with our position being that for those reasons, because the court should have treated Mr. Lanham's accounts by a qualified domestic relations order, it does require recalculation, and that we think the appropriate action in this matter would be a remand for a rehearing on all issues with regard to property, perhaps even requiring the trial court to obtain additional evidence as to value of that property, particularly the Alaska property, and doing an analysis of the non-marital contribution by Mr. Lanham, and treating that property in our preferred position as a non-marital property. Our position is that there was not a gain on it, but to the extent that there need to be further proceedings at the trial court level to examine that issue, that's what we would request. Thank you for your time.
Thank you, counsel. Ms. Laraway, you have 1 minute and 9 seconds left.
Thank you, Your Honor. I want to first address the issue of whether the 60A, whether a substantive change under 60A is a matter of first impression. I respectfully disagree with counsel for appellee. I believe the court can look to In re the Marriage of Shewerman, which is 591P 2nd, 1044, and also In re the Marriage of Victoria O'Brien, now known as Victoria Provenza, which is a 2007 case that was heard at the Court of Appeals. It indicates that if...
Site?
I'm sorry.
What's the site?
I have a Westlaw site, 2007 WL 2328142.
Give me the last one, 2, 3.
28142. Those indicate that if an error is committed by a judge at permanent orders, if it was substantive and not clerical, it could not properly be reopened by 60A. That's the holding of that case. So I do want to first address that. I'm running out of time, of course, but I would like to say that with respect to the Alaska property and it being a separate component, I believe it's important to note that the respondent, appellee, had the burden of proof at trial to prove that that he had a separate interest to that property. He failed to do so, and all of his testimony regarding the Alaska property was found to be wholly incredible by the court. With that, I will end as I'm out of time. Thank you for your time, Your Honors.
Thank you, counsel. Thank you both for your fine arguments. Thank you. The case will stand submitted, and an opinion will issue in due course. That concludes today's docket. The court will be in recess, and the bailiff shall so announce.